Hi, everybody. It's Chris and Lisa, not just me today, with Been There, Got Out.
I had to be on this one.
I know, and if you didn't already notice, there's like a little Chicago hat that's half out of the picture. But we are going on live today, and he's here already. Let me make sure this works. Okay. All right, so we're making sure that Rafe can get on here. He did a great job earlier. We're going to be talking.
Hey.
There you are. Hi.
Hi, how are you?
Good, good. So put your camera down a little, Rafe, because your chin is cut off.
I don't want that.
There, better.
And I don't know if you can see it, but there's a Cubs hat right up in the corner. Put that there just for you.
Cubbies, all right, thank you.
Yes, so we're with the Chicagoland lawyer, Raiford Palmer, who is also the author of this book, I Just Want This Done, which we said in our caption that we recommend to our clients all the time now. Really, really helpful. Everybody loves the title because it's exactly how we all feel. Like, just finish it. I don't even want to be, it could be, I just want this done, or like, I don't want to be here, get me out.
Right, exactly.
For years, we had 3 books on our Mount Rushmore. Yours is the 4th. We absolutely love it.
That is really kind of you to say, and coming from you with all your experience, and you've worked for so many people and really helped so many people, that I know you've seen a lot and read a lot. So that means a heck of a lot to me that my book is that important to you and your clients. I'm absolutely thrilled, obviously. And I hoped I would help people with this. Contrary to what people might think, you don't get rich off these books. Okay, I'm not Daniel Pink or Tom Clancy. So, or, you know, it's not Harry Potter. But it's
Right.
is, can we help people out? Can we deliver the message to a broad audience? And I'm absolutely delighted that, thank you, Ariana, that's nice of you to say. So I hope that people get the message you're trying to deliver, and that they get so much help from your shows and your direct coaching and all that. So, you know, we're all in the same business, trying to help people get from A to B and keep their rear end attached and keep themselves sane as much as possible.
Right.
In a tough
Right. We often say that part of our job, especially in our legal abuse support group, is to teach people how to stay sane under insane circumstances.
Yeah.
And one of our clients wrote that. We didn't make that up.
That's perfect, because you can feel like the world's gone crazy, especially if you're dealing with the high conflict, the borderline personality narcissist, the folks you guys talk about quite often, rightly. You can feel like you're in a crazy world. Absolutely. So it is so good that you do what you do, and I'm delighted that you like the book. So I'm happy to answer questions and discuss anything you'd like.
Okay, well, we have questions for you. And the first one, because we had a wonderful Zoom meeting together as like an intro back in December. I'm trying to figure out how I can say this and stay on brand, because we don't curse on camera, but you can, and all of our clients can, anybody in our community can. But you had said that some lawyers pride themselves on being the #1 bleep hole. Tell us about that.
Unfortunately, so I'm a big fan of lawyers. Obviously, I'm one. My wife is one. We own the law firm together. We do family law in Chicago. STG Divorce Law is the name of our firm. We have a lot of great people working in our team, and there are a lot of great lawyers in the family law and divorce community. There are some bad actors, though, just like any other aspect of life. There are folks that take advantage of people's situations, or I think there really are 2 things. One, there are attorneys that aren't tuned in to the emotional aspect, and they're just doing their job. And they, you know, we're trained in law school to deal with legal problems, analyze the legal problem, and come up with solutions. Very clinical, like being a doctor. You know, here's the symptoms, here's the cure, and there's really no training for bedside manner, which can be, as you know, can be so critical in these cases. I always tell people 90% of what bothers people in a divorce is the 90% that divorce lawyers can't help you with. And the stuff that upsets people the most, the court can't fix. And it's understanding that line, what can be done and what can't be done, is important. And a lot of lawyers aren't good at explaining that, which is one of the reasons for the book, is to try to draw those lines, help people understand what the parameters are and what they can expect, what is realistic, what is not realistic. so they don't spin their wheels and waste a lot of money going down blind alleys. The problem with the system, there's a number of problems. One thing I've seen over 20 years of doing this, we have a binary court system. We have a win-lose system built really well for criminal cases. Well, we can argue details, but generally built around criminal and personal injury and civil disputes like breach of contract. Either you breached the contract or you didn't breach the contract. Either you're guilty or not guilty. Divorce is all about shades of gray, of course. So lawyers and judges and litigants struggle with the fact that, unfortunately, the courts are not good at shades of gray. And the law, it's hard to draft laws that deal with every circumstance. It's not a computer program, so it won't be perfect. And it's far from perfect for a number of reasons. You have, first of all, it's hard to draft laws that accommodate every situation. It's difficult to get, judges have limited time. They are stuck with huge dockets. In Cook County and Chicago, judges have over 1,000 cases apiece. We just received a message from the chief judge a few weeks ago saying they've lost 3 judges to retirement, at least one of which was unexpected, and they're going to have trouble filling those positions. And the judge cautioned people that might add 1 year to already long cases. Cook County is a 2 or 3 year proposition beginning to end if you go to trial. She's telling people, watch out, it could be another year, which is ridiculous for the citizens that are supposed to be served by their court system. So it is unfortunate. But I want to make sure I answered your question about, somebody said no sound. I think you guys have audio, right?
Yeah, we have audio.
Yeah,
We hear you
they're just
fine.
being quiet. So,
Okay, I think everybody else can hear. If somebody else can't hear, just put it in the comments. But the rest of us, I think, hear each other.
if anybody, I hear them fine. If anybody doesn't hear us, please say so in the comments. Yeah. I want to address the lawyering issue briefly. So the court system is limited in terms of time and assets to deal with cases. The other problem with the court system is, thank you, I appreciate it. Thanks, guys. So you've got a limited amount of resources with court process. You have, the other problem is courts are limited because of this in terms of time to hear your case. So everybody sees the movies and they think there's going to be this, and understandably, they have no other source of information. They think there'll be this magical day that will come when they're going to tell the story. They're going to be able to say, Judge, this guy's horrible, or this lady was awful to me for 15 years and she's abusive and all this bad stuff. And it may be all true, but they're shocked to find out they're not allowed to talk about all that stuff. And so they're usually very disappointed if they think there's going to be a day where there's a dramatic speech made by them or their attorney, and the judge says, aha, you're the good person and you're the bad person. You get all the money and the kids, and you have to be executed at dawn.
Rafe, I wrote that speech and I never got to deliver it. My divorce took 3 years, never went to trial, took 3 years. And I don't recall saying much more than my name and address and swearing to tell the truth in court.
Yeah, and the system is not built for that. The rules of evidence are there are two things. State statutes, now in Illinois, the cause for divorce is not relevant in Illinois. We can't even put it in a pleading. So domestic violence, adultery, we used to be able to say those things in a pleading, as well as irreconcilable differences. Now it's just irreconcilable differences. So you can't even get the why into evidence in a divorce case. So it might have been 20 years of verbal abuse or whatever, but unless it directly impacts the children and it's relevant to a custody matter, you're not going to get that into evidence. So the court will never hear that stuff, even though that's critically important to you. The point of, well, what's the point of court? Fair question. I would suggest avoiding it whenever possible, but if you have to go to court, the point of court is if you can't work out an agreement, somebody has to decide. And it's an imperfect tool, but it's the only tool out there, other than alternative dispute resolution, which we will hopefully address during this call, because all of us here are big proponents of mediation, collaboration, staying out of court if at all possible. So I wanted to address, so we talked about the limitations of the court system, the rules of evidence. So the rules of evidence, the way that a lawyer has to ask questions, you can't just tell your story in a narrative fashion. The rules require, as you know, that the lawyer has to ask questions and the person gives answers under pretty tight restrictions. And that means your story will, even the parts that get out, don't come out nearly like you hoped, and it's stilted and in little pieces. And it's mostly financial. Trials are pretty boring. They deal with finances largely. And then the part about custody deals with issues related to the children and who's spending the parenting time with the kids. And that is when if abuse is in play, treating the children, that kind of stuff can come into evidence. But if kids are grown or custody is not at issue for whatever reason, nobody's ever going to hear about that stuff. So that's another problem with the trial system, is a lot of things people think they're going to get to talk about, they won't. The lawyering. Unfortunately, there are lawyers who either are blind to the emotional needs of their clients. They just weren't trained. I don't want to knock lawyers. There are a lot of damn good lawyers out there who just aren't tuned into it because they weren't trained in law school or afterward to pay attention to that stuff. And they're excellent, objectively excellent attorneys. They gather the facts. They ask all the right questions of their clients in terms of the factual stuff they need to know, the money, stuff about kids, things like that. But when the client says they have emotional issues or communication issues with their spouse, with the children, the lawyer doesn't have a good toolbox to deal with. And they may not know to talk to coaches, recommend coaches like you, recommend mental health professionals that can help people with these important issues, and spot counseling issues when they occur. And clients for years would ask me kind of these types of questions, and I would say boss lady just said it's time to grow. Agreed. I mean, this is a place where lawyers can learn and broaden their horizons. I learned a lot in the collaborative training process about coaching and mental health and borderline personality disorder and things of that nature over time, and have read a lot of books on that. And our lawyers train on these issues because it's so important to at least recognize what the issues are and then know when you need other professionals to get involved if at all possible, and be sensitive to the needs of the clients. So a lot of lawyers aren't trained in it, and unfortunately, there are lawyers who are bad actors, who take advantage of the chaos, who capitalize on the warfare between the parties and embrace it. And they will say they're being good lawyers. And how can they say that? The ethics rules say that you're supposed to zealously represent your client. That basically means, passionately pursue their goals, as long as they're ethical and legal. Well, the ethics rules are actually a fairly narrow set of rules. And the American Academy of Matrimonial Lawyers realized that the basic rules of ethics don't cover matrimonial law very well and the myriad situations that come in to play. So they created bounds of professional conduct that are much broader, and I think deal with the situations we run into in family law much better. So we review and maintain adherence to the bounds, since we're fellows in the Academy, my wife Julie and I. Julie Goodman is my partner and my wife, and the lawyers in our firm. And because we believe in them and we think they make us better at what we do. But a lot of lawyers don't know about the bounds, and they don't care about the bounds. And so whatever is technically ethical that they won't get in trouble with or for, they will do. So when a lawyer or client says to them, I want to bury my ex and I want every penny, they will say, okay. They'll say it's going to be expensive, but all right, well, as long as it's legal, as long as it's ethical, and again, that's a narrow set of rules, we will do that. And they pursue scorched-earth litigation, and they pull out all the stops. And eventually the lawyers in your community know who those folks are. And when we get those people on the other side, we warn our clients and we say, you're in for a rough ride. I hate to tell you, no matter what we do, because we can only do our half, they're going to declare war, and all you can do is defend as best as possible and protect yourself as best as possible, because you're probably going to trial, or you're going to go up to the edge of a trial. I hope that answered your question. I know that was a lot.
Yeah.
Yeah, and then some.
I know. So, Rafe, actually, I was thinking as you were talking that a lot of our clients, and I know myself included from the past, like we get so angry and we say, you know, the other lawyer believes my ex. Like, how could they believe this person? We get like so caught up in like, I need to, you know, fix it or prove to them. We say at this point, well, what I've learned, it doesn't matter. It doesn't matter. And what you said too, that's their job. Their job is to advocate for their client.
Correct. And also, don't think the lawyer really believes them. Okay.
Really?
I mean, well, we have to, you know, we have to follow the strategic guidance of our client. So if the client says trial, settle, you know, whatever they're, you know, ethically we're required to let the client decide the objective of the representation. So, you know, my goal is X. I want to do that. So as long as it's legal and ethical, we're required to go to that target. Now, tactics is up to us. So the lawyer gets to decide how we get from A to B. The client gets to decide, I want B or C, you know, whatever. So you can be a good guy or lady on the way from A to B, or you can be a jerk and light as many fires on the way from A to B. Some lawyers choose to light the fires, and some of them think that's a good strategy. And it kind of can be, because being nasty can wear people down. It can be a war of attrition. I use an analogy to World War II, Eastern Front, but I won't get into World War II history nerd stuff. But in strategy, one strategy is wearing down your opponent by just battering them into submission. In a divorce situation, emotionally, financially, and people finally just give up. They say, the hell with it. I'll take this bad deal because I can't stand going to trial. I don't want that lawyer cross-examining me. I can't stand the person. And so litigation can be used as a tool to continue an abusive pattern.
Wait, let me interrupt you for 1 second. That line, exactly what you said, that's what I say at the beginning of every single legal abuse support group is your ex's goal is to wear you down and bleed you dry.
Right. So know what you're getting into going in. Yeah, absolutely. And they'll ruin themselves too. I saw Elaine mention just now, even at their mental health and financial ruin. Absolutely right. And it's not fair. You're right. The next person commented. It isn't fair. But this stuff, unfortunately, what the law thinks is fair is not fair to you and me. So one thing we tell clients, fair is a 4-letter F word. And it's not to make the client feel bad.
I'm writing that down.
That's going to end up as a post.
Yeah.
Yeah. Your fairness is not my fairness. So, okay, so dimming the gaslight says take them with you. Nah, don't do that. Okay, don't go down where they go. It's not a winning proposition. You got to take the high road. It will work out for the best. But you do the best you can under the circumstances. And be strong, but do the best you can to not go down to their level, because that's what they want. So they want to get your goat. They want to see that it's upsetting you. So the worst thing you can do is engage and show that it's getting your goat. And that's classic narcissist borderline, dealing with those folks. And by the way, put my pitch in for the book Splitting by Bill Eddy.
Oh yeah.
It's over there.
Yeah, they love it too. We love it. It doesn't even need to be a narcissist sometimes, just a hardcore person in a case. Splitting's awesome. Bill Eddy's books in general, highly recommend. But it's understanding that you're in that situation and knowing you're in for a rough ride. Take the high road, get the right lawyer who knows what they're dealing with. And then you got to do you're going to have to play the game to a certain extent, but don't exacerbate the situation. What I say is don't do eye poking or tit-for-tat litigation. Just because they filed a motion doesn't mean you should file a motion back. So they did some stupid motion for some reason about how you were 10 minutes late for visitation time. Don't do the same thing. The judges don't like these motions. They really don't. They're going to hear them if they're legal and they follow the rules. They're required to hear these motions. But the judge won't necessarily show you that they think it's bogus. They may deny the motion and you'll think, man, I can't believe they even heard that motion. It's such BS.
Yeah.
It's ridiculous.
Yeah.
Right? But the problem is the rules allow them to present it. It doesn't mean they're going to win. They get a chance to present the motion, which is very frustrating for regular people who see this stuff happen and say, how can this be? This is total BS. I can't even believe it.
And expensive.
Yeah, I always tell people you file a motion, it's $2,500. So we just spent $5,000 running around in circles on a stupid issue. And the one thing we say is, are you getting more divorced? Is this motion getting you closer to being done? There's lots of motions these folks file that don't get anywhere closer to being done. And it's just poking people in the eye. and it's just spending money. It's just meant to harass people. And every false move, they file a motion. I can tell you this, that stuff accumulates over time, and judges get to know who those lawyers are. They eventually figure out who the straight shooters are in the courthouse, who the goofballs are in the courthouse. They have to tolerate them as long as they're playing by the rules. They have to let it happen, but they're going to deny those motions, and ultimately, what I call the meta case in the book, which is everything outside of the case, the relationships between the people involved. Who's the judge? Who's the guardian ad litem? Who are the lawyers? Who are the parties? And what are they doing with each other, vis-a-vis them, each other, the kids? How are they treating the guardian? How does the person come across to the judge? The court and the guardians and the folks involved remember all this stuff over time. And they remember who brought all the goofy motions. And at trial, if something's on the borderline, if the meta case has gone against somebody, those kind of fence decisions are going to fall in your favor because you've been wearing the white hat. You've been the good actor through the case. The court knows, generally speaking, you've been reasonable. Yes, getting your children safe is obviously critical. Kristen mentioned, of course, kids are number one. So understandably, it can be very, very frustrating. The best thing you do is hang in there, find the right attorney, focus on getting to the objective. Don't be distracted by these extraneous motions and other nonsense that come at you. Social media posts where they're saying nasty things about you. They badmouth you to their family and friends. Stay focused on the target of getting done. Work with your lawyer on what's needed to get done. Try to ignore the static. And that's really what it is. It's static. You think it's going to hurt you. People kind of feel like these things are like shots in a basketball game. Like, if they have this motion, that's a shot they've scored, and they're scoring points on the scoreboard. And I'm losing. I feel like I'm not doing anything. So I'm losing, and they're winning because they're doing more stuff.
That comes up all the time with our people where they're like, why do I have to keep staying silent? Why does my lawyer do nothing? And they keep doing all this stuff. We're like, your lawyer probably has a strategy. And by not engaging with the nonsense, it's making you look good. And I'm so glad you mentioned that when the time comes and certain decisions are made, they remember, because I found the same thing in my case. When I got divorced years ago, I had an excellent divorce attorney, and even though they weren't playing by the rules, he's like, we always have to do everything right. You never want to give the other side an excuse to distract right from what matters.
And if they're goofing around with parenting, don't goof around with parenting back. You know, it's tempting. You know, they bring them 15 minutes late without the clothes and the homework. Don't do it back. It's just going to deepen this. It's like a cycle of violence. First of all, you're only going to make it worse. Secondly, you're going to end up, you don't want to have the bad guy hat on. So do what you can to take the high road, as hard as it is, and I know it's hard. Focus on the objective. Work with your lawyer to focus on what gets us to trial. Here's another thing. If you have somebody who's abusing with litigation, the only way to end it is get it done with a trial. And now trials are not fun because they cost a lot of money. There's prep time and a lot of work has to be done to get there. But the only way to end is a trial date. So, trial dates focus everybody's attention. 98% of cases settle in the United States in divorce. Yours will likely be one of those. When does it settle? That's the question. Some of them settle in 3 months, some settle in a year, some settle the day of trial. Trial, everyone knows it's going to be done at that point. So it will motivate a settlement. 98% of the time, the vast majority of the time, you're going to settle, and it'll take the trial date to get the case to settle. Otherwise, they'll just keep screwing around with going around the mulberry bush with all the nonsense, because unfortunately, it's fun for some people.
That's an understatement.
Yeah.
Or we say they have nothing else to do with their lives.
Well, once you're out of if your partner is a toxic person, once you're out of the relationship, all they have left is the legal system, money, and the kids.
Yeah. You're not fun anymore. They don't have any buttons to push. So the lawyers only have 2 buttons to push on the control panel. We have court and talk to the other lawyer. That's it. And once people realize the toolbox is limited, it helps understand what the lawyers can do and can't do. all we can do is pick up the phone or send an email or have a meeting or go to court. Those are the only tools. So you're absolutely right, Chris, when people, if you buy into it and you show that they're getting your goat, they love it. And they're just going to amp it up. All they do is push the button harder and harder until it stops working. And then even when they think it's stopping working, they bang it harder and harder. And they might keep doing it pathologically until the case is over and beyond. You know, we have cases, unfortunately, that are in post-decree litigation for years on silly stuff.
Rafe, after 3 years in the legal system, not going to trial, 10 days after the judge signed off on our settlement, she brought me back to court to completely change custody. 10 days. I was served 10 days later.
Yeah.
Unfortunately, the family court judge had seen it, and she was, you know, she knew that this was abusive litigation. She tossed it right out. But
yeah, and that's the key is the judges, obviously they're the first line of, the first line of defense is a lawyer who says no. And one of the hardest things for lawyers is to say no, because it's easy to say yes, like being a parent. And when clients say, I want this, I want that, one of the hardest things for an attorney is to say no, and here's why. Because clients generally want their lawyers to do what they tell them. So one thing we talk about is the importance of, when we talk in our meetings with our lawyers, is what we call client control. And that doesn't mean we're like robots. It just means when the clients want to do something that you know is not in their best interest, then we have to talk to them and say, this isn't good for you and here's why. You know, normally some lawyers would say, great, I get to spend another $5,000 of your money. That's not how we operate. And good lawyers don't do that, because ultimately the client's not going to be satisfied when it's all done, you know, in the long game. So the good attorneys know that the better thing is to get the case done as efficiently as possible and have that client be satisfied and send you 3 more clients down the road, than at the end to feel like you burned them out for every dollar.
Yeah. My wonderful divorce attorney is like, Lisa, I don't want any of your clients. Your case kept me up at night. Like, I don't want that just like too much. The high conflict.
There are lawyers who, you know, they shy away from the high conflict cases. They want to work with ones that are easier, and they don't want to deal with that stuff.
Yeah.
But
yeah.
it's important.
Yeah. All right. Talk to us about, we talked about stereotypes relating to family court, but I'm also thinking of any myths that people should know, like where most people think, oh, it's really going to be like this. Like, we know you're not going to have your day in court to tell your big speech, which, you know, I've tried like multiple times, but didn't have. Got little bits here and there. But what other stereotypes or myths do you think are important to bust?
There are a lot that we talk about in the book, and let me think about some of the good ones. Well, we talked about court, where you don't get the dramatic, you know, reveal in court. The other myth is that that one person's going to get everything. I think I alluded to this in the beginning, that there's a winner and a loser. Both people lose. You know, and the key is controlling the landing. I use a lot of airplane analogies, but the thing is, can we land the plane and get everybody out safely? Nobody's happy they're getting divorced. The day you get married, you don't say, gee, I can't wait till the day I get divorced. You know, we'd rather be happily married. If it doesn't work out, the myth is that, as I said, that this is going to not work out for people. So let me look real quick, because I have a whole bunch. Oh, here's a bunch. These are good ones. So I deserve sole custody. That's a good one. The law in general prefers that both parents parent a child. So sole custody is a tough nut to crack unless there's extreme cases of abuse or neglect for a child. And one extreme example I like to give is child abusers, like literal convicted child abusers, get to see their kids under controlled conditions, but they do get to see them. The standards for parenting in the divorce court are very low. Mm-hmm. Because you and I are kind of, say, everyday people would say, oh, the parent keeps, I'll get a call or a consultation with somebody say, well, he keeps the kids up till midnight every night and doesn't feed them really well, and they never have their coat on when it's cold, and things like that you and I would say, yeah, that's bad, and that's not good stuff. He doesn't do their homework, and their grades are suffering as a result. We would all agree that's not good behavior. that doesn't keep a court from giving that person parenting time. So one myth is, don't think that some normal misbehavior as a parent or pretty bad parenting will get you sole custody. It generally won't. So understand that that fight is probably not worth having, and it's an expensive one usually. Now, in the cases of true abuse, neglect, yes, sole custody may be the only way. But understand that sole custody, judges are normally preferring that both parents parent the children and have decision-making in that. So it's, understand that's a tough road to hoe. That's a big hill to climb. Also, here's another one. The judge is biased. You know, they're all in the tank. No, I've been in this a long time. I've done lots of different kinds of law before I did divorce. The judges are not getting rich off this job. Nobody's sliding money under the table. That's movie stuff. I guess it happens once in a blue moon, which is why it makes news, because it is unusual. So the things we hear about, we need to remember are outliers. They're not the common case.
Let me ask you something about that, Rafe, because what about, you know, judges are former lawyers.
Mm-hmm.
I mean, they're still lawyers and they know each other. So what about when they have a lawyer practicing that they're friends with?
It happens, obviously. The judges have to follow the rules. I mean, I'm not going to make stuff up and tell you there isn't some influence there potentially, but judges have a code of conduct as well, and they can lose their jobs as well. I have generally experienced judges to, when it comes down to actually trying a case or listening to the evidence, to be as fair as they can be on a general basis. Are there some judges who I think tend to lean towards one lawyer when something's on the fence? Yeah, it feels like that. Do I have proof? No. Can it feel like that when you're in a case and you feel like you're on the losing side all the time? And also the whole win-loss thing, I kind of want to, that's something that's important to sort of calibrate. Like we talked about before, you may feel like you're losing and you're really not. You know, it ain't over till it's over. It's not done till the trial. So,
yeah, I myself was really concerned with part of my case because I knew, and my, you know, a lawyer that was helping me on a limited scope said, you know, your ex's attorney is good friends. They were in the military together with the judge. He was wearing a military pin. They were using military language. And she said, we're not going to do well. And I felt like, oh no, I'm just going to lose, even though I already had these great orders that I was just trying to get enforced. So it took 12 court appearances, but the judge did rule on, you know, in favor of the law, and I did win what I needed to get. But it just took, I felt like it took longer, but I still was able to get there. So I know when our clients will say the judge is biased, I just say, what you just said, yeah, but they have to follow the law. We'll come down to following the law.
And they're trying to do their jobs. I mean, they're human, yeah. So is there some bias? Yeah. If it's extreme, somebody said, what if they know each other and he's a first responder? Generally, that's not a basis for the person the judge to recuse themselves, meaning withdraw from handling the case and switch in another judge. You might be able to bring a motion to change judge, but the bases for doing that are pretty narrow, and usually it has to do with conflict of interest, like the judge represented the other party at one point or their law firm did. That can be an issue, or actually in our circumstance, my wife's ex-husband is now a judge in one of the counties where we practice, and we can't practice in front of him. Yeah, he's not a divorce judge, but if he was, we couldn't practice in front of him for obvious reasons. And we front that stuff. So it can be frustrating if you feel like there's bias like that. I can just tell you, it's just not a major issue. I wouldn't get too wrapped up about that. Try your case, focus on the evidence, and if you have the basis for a recusal or for a motion to change judge, then bring the motion by all means and get another judge. But otherwise, have you and your lawyer do the best job that you can do. And that's really all I can say about it. But I would say it's not as bad a problem as I think people perceive it to be. Here's another one. The judge will sympathize with me. This is part of, I get to tell my story. First of all, the judge generally won't hear your story. Secondly, it comes down to math for most of for the financial case, it's largely a math problem. And sympathy with one side or another, or whatever the story is, it isn't really going to be helpful unless, for example, you're disabled and you're looking for alimony. Okay, now there's a reason for the court to look at that factually and add that into the calculation for alimony. But just one person being sympathetic or whatever. Here's a good one where this comes into play. Typically, narcissist borderlines look really good when they're on stage. So they'll be nasty to the person that's the victim, and they'll be wonderful in court. They testify great, they look great. And the client will warn me, everybody says he's awesome, he's amazing, but I can tell you he's nasty. And he'll say, I feel bad because nobody will see what a jerk he is, or, how will that get across? Unfortunately, the guy is going to look good, and all you have is the evidence to present to either show he's misrepresenting things, maybe he's not telling the truth. Well, you've got documents and the other person's testimony and credibility and maybe some other witnesses to show that that stuff's not true. So it definitely is a challenge, but courts aren't just going to sympathize with you because you're a nice person. That might help you with the meta case if they think you've been a straight shooter, like I said, through the whole case, and there's something on the fence. You're likely to tip it in your favor, but the judge's job isn't there to sympathize with people's stories. It's to decide based on the law and the evidence.
I'm so glad you mentioned that, because that seems to be a big thing, especially all over social media, is lots of complaining that the judges aren't sympathetic, but they don't have, like you said, they don't have the time, and it's so limited what they can do. So again, it comes down to the evidence, but there's also adversarial versus inquisitorial law, right? So it's it's not just the evidence, it's how it's presented and the setting that it's presented in, who manages all of those together the best.
Yeah, and one person just asked, when will they see your evidence? Yes. Dimming the Gaslight said, will they see your evidence? Yes. They'll see the evidence and they'll hear the story related to the evidence at the trial. Unfortunately, there are 2 points where the judge hears the information. One's called a pretrial conference, or that's what we call it in our jurisdiction, which is sort of it's a settlement discussion where the lawyers talk in the judge's chambers typically about the facts of the case, present the financials, and say, Judge, we think the outcome should be X and Y. And the other lawyer says, we think it should be A and B based on the information. And the judge says, well, based on what you're showing me, here's my recommendation to settle the case. And it's an attempt to get people to settle. And typically, if that fails, if people can't settle, then the court will set a trial date at that point. And the pretrial conference is typically scheduled after the discovery is complete and all the information is exchanged. So the judge isn't really hearing evidence because the witnesses aren't testifying. The lawyers are just giving a summary form to the judge in half an hour. But if the lawyers are laying out the facts, if the finances are correct and everything, you might get a pretty good idea of where the judge would head, assuming the evidence comes in that way at the trial.
I have another possible myth for you to bust. Here it is. The judge will read all my motions and read all the evidence and see my exhibits before we get before the judge.
I hate to tell you, no.
It took me a while to learn. I was reading these beautiful motions and being like, how you get there and they say, okay, so what is this about? And it's like, didn't you read it? Of course not.
Here's here's a tip for you out there who have lawyers, by the way. If your lawyer writes these really super long motions, tell them to shorten it up, okay? Judges are human too, and they're not going to read a novel. I don't care how compelling the story is. Get short and sweet. First of all, saves you money. Secondly, gets to the same objective. The judge only has so much time. If you're lucky, they're going to glance over it before the hearing. And the top of the motion is, I train lawyers all the time. The top of the motion should say, in a tight little format, what you want. What is this about in like 2 sentences? And then why, A, B, C, D, and then what you want again at the end. Classic persuasive writing. But a lot of lawyers write these long things, and they're like frustrated novelists, and the judge doesn't have time to read this stuff. And so it's, short is better. Brevity is the soul of
they always say make it simple. Keep it as simple as possible. With our clients, we're always like, think about it like when even at trial, like commercial, short commercial.
Yeah. And we all think, look, we're all pressed for time. We all have short attention spans. So does the judge. Play to win. So, play to the short attention span. You're going to need to understand your audience. And also being overly emotional is not good. So the judge is trying to handle things in a dispassionate fashion. It's very emotional to the client. But if the lawyer's overly flowery and over the top in the presentation and kind of ridiculous, there's no jury, right? There's no studio audience. It's Zoom maybe. And the judge doesn't like a lot of drama. They like to get the signal to noise ratio to be very good. So tell the judge the message, get the information across, and then let the judge decide. No, that doesn't mean not be passionate. You need to be passionate about your client, but being ridiculous turns the judge off. Going way over the top. Measure it to the audience and the moment. If it's abuse of a child, absolutely go over the top. If he's parking the car in the driveway behind my car and blocking me in, okay, it's a little less dramatic.
Right.
It's
okay. Let's talk about how courts pour gas on the fire, and if there's anything we can do about it, especially the family court stuff. Like, how do they make it worse?
Unfortunately, judges make it worse by not setting trial dates early. So that's one of my pet peeves. I've been asking courts for years in our area to set early. So in other courts, you go to other areas of the courthouse, you go to personal injury litigation, you go to commercial litigation where people are suing over money. Judges set trial dates very early. Typically in the first 60 to 90 days, they'll set a trial date. It might be out 9 months or a year, but they'll set that date. In federal court, they're very strict. They set a very tight schedule on discovery and trial. What that does is it makes everybody focus and actually get the cases done. Well, that's amazing. Well, when there's no trial date, everybody has the ability to spin their wheels forever and drag it out kind of endlessly. So if any divorce judges are watching, why can't you set trial dates early? There's nothing wrong with it. It works everywhere else. Why not divorce court? And the excuse I hear is, well, we need to wait till all the discovery's in. No, you don't. There's no divorce case that can't be done inside a year, in my opinion. I don't know why it can't be done in a year. There's nothing. Even the most complex cases, if you get on your horsey and you start gathering discovery and talking to the witnesses, you should be able to get a case done in a year.
Yeah, our state has a law where you have to set a trial date from the year the paperwork is filed. If it's not done, you go right to trial.
We have a law that requires a hearing if kid issues are not resolved. We have to have a hearing. I think it's within it's 180 days. There's a pretty tight requirement, and that's helpful. But I have to tell you, what people are doing is they enter the parenting judgment and they're dragging out the financial, and that's still taking 2 years or 3 years. So so number one would be judges have to set earlier trial dates. Lawyers should push for trial dates sooner, and by all means, get discovery done sooner. So here's another tip for those of you who are in divorce litigation now. The faster you cooperate with your lawyer to give them all the information about your finances, the better. Do not wait. Don't hesitate. Dump the stuff on them as soon as possible, because that's the only part you can really do is get them all that information so they have the information and they can convey it to the other attorney.
How about the other side not complying with, this was my issue and many of our people, is the other side doesn't comply with discovery. And we go 9 times in a row and the judge says, you have another week, you have 3 more weeks, you have another month. And it's like.
Another judge problem, judges not being hardcore on discovery violations. This is a huge, huge problem in divorce court. I can tell you about Illinois. I can't tell you about elsewhere, but I'm suspecting it's true elsewhere. For whatever reason, I would tell you, in other courts, personal injury, civil practice, federal court, judges are super hardcore in federal court. You have mandatory disclosures right away. I used to practice in federal in one of my past lives. And if you screw up and you miss those deadlines, you're done. You're out of luck. Well, if judges were tighter about discovery sanctions and they said, if you don't disclose the stuff within X amount of time, you're going to get fined X amount of dollars in attorney's fees or whatever, they'd wake people up and get it done. Here is one of the unique challenges of divorce that sort of explains why discovery is a pain in the ass from a judge's standpoint in divorce. We need the information. You're going to get divorced one way or the other. In a personal injury case, if you fail to disclose the information, if you're the plaintiff's lawyer, you don't come up with the evidence, you just lose. In a divorce court situation, the judge wants to rule on the merits and wants the evidence in the case. So they bend over backwards to give everybody every opportunity to get everything in the pot. They don't want to decide a case by default, which means like somebody forfeits. You know, they fail to comply, so they just decide against them. That's never going to happen in divorce court because that's going to go up on appeal, get appealed, and it's going to end up right back in the judge's lap. So the judge is going to bend over backwards to allow compliance.
Yep, that's been my experience. That's why it's like 90-ish court appearances in all these years just to get enforcement. They keep saying, "Well, give them another chance." And is there another way to do it? And I'm just like,
the only thing you can do,
I mean,
the only thing you can do is subpoenas. You know, go out and get the stuff yourself. That's sometimes you don't know what it even is that you're looking for, or get consents signed by the persons, and then go to the provider and get the information directly. But yeah, it is a huge problem. Discovery, neglect, and abuse, and it could be, you don't know if it's the lawyer. It could be the other party just not giving them anything, either because they're lazy, they're intentionally delaying, any number of reasons, and that drags a case out drastically. Meanwhile, you're burning money and time.
Speaking of that, tell us about the whole cost-benefit analysis.
So this goes part and parcel with getting it done and understanding what is realistic in terms of objectives and what is not realistic. So understanding, oh my God, 2.2 million over 17. GCM, I feel for you. That's crazy, but I've heard of things like that in some cases in Chicago where people are spending $1 million plus on fees, which is totally insane. I believe it. I'm horrified to hear it.
Me too. 17 years. Yep.
I mean, who really wins? Did anybody win? Isn't that money better spent on kids' college education? Or whatever. $2.2 million. That could have bought a lot of stuff for that family. That's insane. Yeah. So you got to follow that discovery. Yeah, well, that'll be fun. It'll be full of bank statements and stuff, Lisa Brady. So that'll be fun to read, unfortunately. Okay, so what's your question again? I apologize.
Cost-benefit analysis.
Thank you. I was just reading the comments. So having a realistic idea of what your outcomes could be. So I have a realistic range of outcomes in mind. Know what's doable in court. So talk to your attorney, understand, I would say, like, we consider it guardrails. Left to right or top to bottom, what's my range of potential outcomes in this case if we go to trial? X amount of maintenance or alimony, X amount of child support, X amount of assets. What is that range? What can I expect with custody? And it's like, tell me the truth. Lawyer, like, no happy talk. Unvarnished, what do you think is my potential outcome? Understand what that range of outcomes is, and then understand what it's going to cost to get there. So if you can get a lawyer who will tell you the straight story, what is it going to cost me if I go through litigation and I go from now to that point? How much do you think it'll cost? Now, lawyer will tell you it's hard to estimate because I don't know what your spouse is going to do and all that, and that's true. But even a ballpark gives you an idea. So adding that into the outcome range, and I talk about this in the book in detail, show you how to run the calculations, that shows you what kind of cushion you have around the potential range of outcomes to settle. So I'll make a real simple example. Let's say that let's just say that in the case you could get $500,000 at trial. I'll just make it real simple from a financial standpoint. But it'll cost you 50 grand to get there. Then you know that plus or minus, if you have now 50K ready to play with. So if they offered you 475, take it and run. There's no sense in winning. You try to get the other 25 grand and spend 50 to get there. Well, what did you do? You just dug yourself a hole.
Right. So, and the emotional cost and the time cost of what it takes to get there. Right.
And it's so important. You put on one of my videos, which I appreciate, on your post, and you said the 4 costs of divorce: emotional cost, legal fees, the financial cost, your cash burn rate. You're spending money along the way. So is your spouse, not on lawyers, on life, buying clothes, moved out to an apartment, and the drag on your life and career. You're not focusing on your job. Your mind's on the divorce case. You're spending all this time talking to your lawyer. So all that stuff, and opportunity cost is a 5th. What's the good stuff you could be doing? But you can't because you're still married and you're stuck dealing with the divorce. So if you have the cost benefit analysis in mind, you won't waste time on extraneous stuff. you will be efficiently getting towards the objective. And that's the key.
Yeah, excellent. Okay, let's see. I think we talked about some of the other stuff. You know what? Actually, I think we covered most of it. So talk a little bit more about your book and how people can find you.
Thank you very much. My book is I Just Want This Done. How
We've
Smart
got one
Successful.
too.
Thank you. Thank you. I don't know if it's flipped. Is it reversed? I don't know. I don't want to push a button on the screen and screw up my live feed. I Just Want This Done. How Smart Successful People Get Divorced Without Losing Their Kids, Money, and Minds. On Amazon, all formats, hardcover, softcover, Kindle. Also on wherever you get ebooks. It's Apple Books, Nook. It's available anywhere as an ebook. Audiobook just dropped. So if you prefer audio, it's available on ACX and Audible as an audiobook. And it was fun to do the audiobook. And I hope you kind of feel my emotion come through in the audiobook and sort of emphasis on things, because you get to sort of communicate with people in a way that, thank you for that. And that's why it's gold. Thank you. Thank you. No, I really appreciate it. We were, when I worked on the book, so many clients will tell you, and people say, you know, they sigh after a year and a half of litigation. I just want this done. Just get me out of here.
Yeah.
And you feel for people. And so even though the word, you know, you're supposed to have the word divorce in the title because Amazon's a search engine and all that. I like, okay, fine. I like this title too much. So I'm sticking with it. Hopefully people will find the book. But thank you. I appreciate the compliment. And I hope you enjoy the book. The ebook's only $9.99. Audio, I think, you know, if you're one of those Amazon Kindle or the Audible members, you know, it's just part of your membership. If you are contemplating divorce, in the middle of a divorce, post-decree, the mindset stuff is valuable. The cost-benefit stuff will help you. This helps at any stage. Mindset, way that lawyers think about cases, do's and don'ts, dealing with your kids. It's all in here. This is the stuff.
And even if it's not high conflict, Rafe, right? Like, I mean, what we deal with is high conflict people, right? But
move closer.
Oh, tell me move closer. You know, we deal with the high conflict cases, and this certainly applies there. But it's really for anybody, right?
It was aimed at everyone. And this, I'm selling books in Canada and the UK because it doesn't matter that it applies anywhere. The whole idea was to write a book of the advice I've gleaned over 20 years counseling clients on the stuff that is, we'll post the title, thank you, of the book, thank you. And the book can be easily found. I Just Want This Done can be found on Amazon, and there's links to it in my bio on TikTok and Instagram and all that. And the website is ijustwantthisdone.com. If you Google Raiford Palmer, just my name, you'll find the book too. So I'm easy to search because my name's a little unique. Yeah.
Right. And when Lisa posts this on Instagram, this is the live version, but she'll put it up in a little while. She'll be sure to put the title in the description.
Yeah. So high conflict or not, you'll find it appeals to everybody. And I tell stories in the book. This isn't just some dry book full of advice. I tell a story. First, I tell my story. I tell kind of the client's story, kind of like everybody's situation. You'll find it's very familiar when you read it. And it's a pastiche of many, many clients over years. And then my story, I've been divorced. I was married for 24 years. I got divorced. Thankfully, I have a very reasonable spouse. We get along well. And we had a very amicable divorce. And yours can be too. If you follow the precepts in the book, this will help you, whether you have a lawyer or you don't have a lawyer. I wanted to take all the stuff I learned in that period of time and package it for our clients and for everyone else. So
and for our clients.
Yep. And I'm delighted to get the chance to speak with you. Thank you.
Oh, thanks so much. So we'll definitely be in touch, and I'm sure we're going to do this again.
Awesome. It's really my pleasure. Thank you, everyone watching, for taking the time. I really appreciate it. And thank you, Chris and Lisa. Really appreciate you taking the time to share my message with your audience. Thank you.
You're welcome. Okay, bye.
Take care.